Hello, my friends, and thank you so much for coming to spend part of your Thursday, July 18th with me of 2024. A lot of things happening today. A lot of things happening today on the Karen Read case. Not one, but two major things happened today. The second thing happened after I created the title for this stream, which I don't even remember what I'm calling it again. What am I calling it? Karen Read Juror files an emergency application out of fear, citing fear of harm. And that is one thing that we're going to go over. But in the meantime, since I posted this stream, a fifth juror has come forward to the defense who is confirming that allegedly the jury agreed to acquit Karen Read on charges 1 and 3. So now we're up to 5 out of 12. And the judge has already ruled on the emergency motion, so there's that as well. It's crazy. It's crazy. We didn't even get a chance to go over the defense response to the Commonwealth's response yet, but that's okay because it's basically just a bunch of case law. And you know, and I know that Judge Beverly Cannoni has rights, and she's got a lot of latitude when it comes to what she decides that she is going to do. I also heard some chatter that there's been a new judge assigned, at least for the conference that's supposed to be on Monday, July 22nd. And I'm just checking the court docket and right now to see if that has since changed. Last time I looked at the court docket, it was not Judge Cannoni that was assigned to this hearing on Monday. It was a different judge. So give me a second here and I'll see what pops up on the calendar. Oh, it has gone back to Judge Cannoni. It is back to Judge Cannoni, my friends. Yesterday, it was a different judge, and she's taken it back. She's there. There was a lot of buzz on the interwebs about why this other judge was assigned. Some people thought perhaps Judge realized she may be a witness and assigned it to someone else, or maybe she was on vacation and it was just going to be a scheduling conference, but it is currently scheduled for Monday at 2 p.m. in the civil part, courtroom 20, in front of Judge Beverly Cannoni. So it's back to Bev, people. It's back to Bev. So let's, how's everybody doing? How's everybody doing? Doing okay? You freaking out? It's really nothing to freak out about. I knew this was coming. I knew that there was going to be a juror who was afraid. And quite honestly, rightly so. Because if people out here are being attacked who are disinterested third parties that have nothing to do with the Karen Read case, how do you think a bunch of jurors are going to feel when they're done with jury duty and all their friends and family who may have been watching social media during the time they were deliberating and hearing this case for the 10 weeks that they were assigned to this case? How do you think those people are going to feel when their friends and family started telling them, oh my, you can't even believe what's going on out there. You can't believe what's going on out there in social media world. Vitriolic. We've discussed this several times. This is the most vitriolic case I've ever seen outside of Depp v. Heard, and that was a civil case. That was a civil case. And I believe, and you can correct me if I'm wrong, but I believe in Depp v. Heard, the jurors' names were not released for a year until a year after the verdict came out. And so I think that this is a perfectly reasonable request on behalf of this juror Doe who did not want to name themselves. And quite frankly, who could blame them, right? And thanks on top for being on top of your super sticker. Angel Fire gifting 5 memberships. Thank you so very much. Pilgrim Shadow coming in with the 10 spot. If you get confused, listen to the music play. Ringland's Tower. Thank you for the Grateful Dead reference. And LA became a new member. Thank you for being a new member. So what I think we should do first, my friends, is let's look at this information from juror number 5. And then we're going to look at the information, the emergency petition filed by a juror who is known as now Juror Doe. And we don't know, by the way, if Juror Doe is one of the other jurors that has already given information to Alan Jackson or one of the other jurors that was referred to through an intermediary. We don't know, but we do know that this juror had to go out and hire an attorney at their own expense to file this emergency petition. And we do know that this emergency petition was already granted today, but let's take a look at it. First, let's take a look at the juror number 5 paperwork, because I'm sure you might be interested to see that if you do not know. Somebody said, do you know if it's a real juror? Well, I don't know which juror you're referring to, whether it's the one that came forward through Alan Jackson or the one that came forward through the other attorney, Juror Doe. But either way, I would submit to you that an attorney who is an officer of the court, by the way, would not falsify an affidavit unless they were pretty damn sure that it was an actual juror in this case. So I am confident. You should be confident. And nobody should be out there harassing anybody, is really all I have to say about it thus far. There are certain names that I do not want mentioned in this chat. If they are mentioned, they will be deleted. If you know, you know. And there's no rumors. Thank you so very much. I am not allowing misinformation, disinformation, rumor, speculation. Yeah, why wouldn't, but here at KPT, of course, Juror Doe is a real juror. Why wouldn't it be a real juror? I don't think any attorney is just going to file a petition on behalf of a person unless they have verified that this person is a real juror. I mean, as an officer of the court, you're perjuring yourself. You're signing an affidavit as to the truth and veracity of what you're filing. Know what I'm saying? Okay. All right. Okay, here we go. So this was filed this morning. Not this morning, actually this afternoon. July 18th at 12:41 or 2:41. I think it's 12:41. This is the defense's. These are the defense's papers about juror number 5 and the 5th juror, and we are going to do these first. Here we go. Defendant Karen Read's second supplemental memorandum in support of her motion to dismiss. Now comes the defendant Karen Read by and through undersigned counsel, and hereby respectfully submits the second supplemental memorandum in support of her motion to dismiss, filed July 8th of 2024. As reflected in the attached affidavit of Alan Jackson, a 5th deliberating juror, Juror E, has confirmed that the jury was unanimous on 1 and 3 and that Karen Read was not guilty of those charges. Alan Jackson's second supplemental affidavit, paragraph 4. Based on the attached affidavit and all of the reasons set forth in its opening motion, first supplemental memorandum and reply, the defense respectfully renews its contention that the jury acquitted Ms. Read on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial as to those counts, and therefore the double jeopardy protections of the federal and state constitutions require that those counts not be retried. If the court would prefer to rule on the basis of affidavits executed directly by the jurors, the defense respectfully requests permission to initiate contacts with jurors A, D, and E for the sole purpose of asking them to affirm the accuracy of the 3 affidavits of Alan Jackson. And remember, Massachusetts is a state that requires court permission for attorneys to reach out to jurors after a mistrial. So he's asking permission to do that. He can't just go out there and get affidavits from jurors without special permission of the court. And that's it. Short and sweet by the new attorney who they have hired, since we have theorized Yannetti and Jackson might be called as witnesses in this proceeding regarding these jurors. Martin Weinberg, or Marty Weinberg, the big guns are coming out. Moving on to the next affidavit of Alan Jackson that is in support of this supplement. I, Alan Jackson, declare that I am a partner in the Los Angeles law firm of Worksman, Jackson, and Quinn, LLP, and I've been licensed to practice law since 1994. I am counsel for Karen Read, docket number, there's the docket number, appearing on her behalf in the Commonwealth of Massachusetts pro hoc vice. Here's your Latin lesson of the day. Pro hoc vice means, basically it's Latin, but it means that he's admitted for the purposes of this case. And in order to do that, in order to be admitted into the state of Massachusetts for purposes of the case, you have to be sponsored by an attorney who is licensed in Massachusetts, and that you have to fill out paperwork and sign some affidavits that you're going to uphold the laws and, behave properly in Massachusetts court. And he is sponsored by David Yannetti and David Yannetti's firm. That is what a pro hoc vice means for purposes of this case. On Wednesday, July 17th, 2024, I was contacted by Juror E, true name and identity withheld to maintain anonymity. Based on my conversation with Juror E and that juror's physical description of himself or herself, where that juror was seated, and that juror's name and occupation, which was also disclosed during the voir dire process, I was able to positively identify Juror E as a seated deliberating juror in the trial of this matter. Juror E stated that he or she decided to contact me to provide information about how the results of the jury's decision-making following deliberations. So this juror just reached out to him yesterday. Wednesday, July 17th. Today is Thursday, July 18th. This was filed toot sweet. Juror E explained that the jury was unanimous on 1 and 3 and that Karen Read was not guilty of those charges. Juror E went on to state that the only count on which the jury was deadlocked was in relation to the lower charges on count 2. I took that to mean the lesser included offenses associated with count 2. Juror E indicated that he or she was happy to provide such information but wished to remain publicly anonymous. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and the state of California and the Commonwealth of Massachusetts, executed today, July 18th, 2024, Los Angeles, by Alan Jackson. So remember, the judge still hasn't had anything to say about this particular motion, about whether or not she's going to allow further inquiry into these jurors and whether or not they actually did come to a consensus and unanimous verdicts on counts 1 and 3. But as far as we know, the verdict slips were not filled out. They were not handed into the court. And we don't know what's going to happen or what the judge is going to rule. In my opinion, in the interest of justice, she should absolutely have a hearing. I don't think it should be public. I think it should be done either in chambers or somewhere with no cameras. Maybe a transcript could be released later. And I think that the jurors should be, in the interest of justice, check and see if this is true. Now we have 5 jurors out of 12. That's my opinion. Is she going to do that? I don't know. People are saying it's unheard of. They don't do that in Massachusetts. Well, I found a case where they actually did trying to do it. People are saying out there that the deliberations of the jury are sacrosanct and you can't question them about it. You can't question, what they talked about. But that's not really what we're doing here. What we're really doing here is trying to find out if they came to a consensus or a unanimous verdict, as 5 jurors have allegedly come out and said that they did, with regard to second-degree murder, which was count 1, and count 3, which was leaving the scene of an accident causing bodily injury or death. And if they did, then double jeopardy should apply and she should not be tried again on those counts. There was a case. Do you guys remember this case? Out of Cape Cod. And thanks to so many of you who pointed this out to me. In Barnstable County, there was a case. It was a woman by the name of Krista. Hold on. Worthington. Krista Worthington was murdered or found dead in her apartment in Truro, Truro, which is part of Cape Cod, on January 6th of 2002. And what I found so interesting when I started doing like a deep dive into this case of Krista Worthington, Colonel Maughan was involved in this case. Okay. So there are some of, right? This is right. Krista down the Cape. Right? Remember that case? Okay. So in that Krista Worthington case, this goes back all the way back to 2002. There were a lot of suspects in that case. A lot of suspects. In fact, there was some information that they got DNA from like every male who lived in Truro year round. like it was crazy. And eventually, there was a man that was convicted, and his name is Chris McCowen, McCowen. He is still in prison, and he swears that he didn't do it, that he's innocent. And in that case, after the verdict, there were some allegations of racial bias being discussed in the jury room. All 12 jurors were called back and questioned about that. There's a special about that, Susan? Yeah, I didn't see the special. I just found an article that was relatively recent. The article that I found from, I think it was like CBS or something, was like literally from 10 days ago. But also I looked back at the old articles, and I'm looking right now. I'm looking at the court decisions. He's tried to appeal this a couple of different times, but he's still sitting in prison. So the jury was called back and asked about if whether or not any of this was true about the racial bias that may or may not have been talked about, discussed, displayed during jury deliberations. And so it's not unheard of in Massachusetts, as a lot of people want you to believe. At 48 Hours just released an episode on this case. That's interesting. Thanks, Keita G. Stephanie says, we have Truro in NS. I was a little freaked out for a short moment. Oh, where's NS? Nova Scotia? This is on the Cape. This was on the Cape, 2002. This man is still sitting in jail. He has an IQ of something like between 70 and 76. And they found some DNA. It was a rape and murder case. Look it up. So it's happened before in the state of Massachusetts. It's not 100% unheard of, but what should we do in the interest of justice, right? You've got 5 out of 12 that are coming out and saying this. Shouldn't it at least be looked into? The Commonwealth just comes out and says, nope, 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 nothing to see here. You shouldn't even look into it. But isn't the Commonwealth supposed to be interested in finding justice? Not just getting a conviction, but actually finding out what really happened to Officer John O'Keefe. He was the trash guy, Wendy darling. He was the garbage man. He was Krista Worthington's garbage man. And Krista Worthington got pregnant. She had a baby with a man who was married and already had 6 kids. I mean, there were a lot of other suspects. Technically, 3 out of 12. Yes, that is correct. Technically, 3 actual jurors, right? And 2 who came through intermediaries, or who intermediaries gave information to. But because the defense nor the Commonwealth, nobody can reach out to the jurors directly, we have to assume that Alan Jackson or David Yannetti would not lie in their affidavits to the court as officers of the court. And in the interest of justice, maybe at least just look into it, see if it's true. It's my opinion. U.S. rate of wrongful conviction, says Daria, is 5%. In Massachusetts, the rate of wrongful conviction is 7.2%. I don't know where those statistics are from, but cannot confirm nor deny whether that is the actual case. But I found it interesting today that a 5th juror came forward, and who knows how many more might come forward, or how many more may want to, but they're afraid. And here's what happened today. As you recall, because we went over it, the judge sua sponte, meaning on her own, issued an order impounding the jurors' names. Impounding is a weird word, but it just means that they're sealed. The jurors' identities were sealed for 10 days. That 10-day period expired today. So today, a juror filed an emergency petition through an attorney to try and get that 10-day period extended, because, as you will see when we read this juror, who is known as Juror Doe, or is calling themselves Juror Doe, is afraid. There will be no closed captions, wandering thoughts on this until after it posts. That's just the way YouTube is. There's no live captioning. Sometimes we have captioning if I'm playing a stream of a trial, and then we can get captioning then, but there's no live captioning on YouTube. It's just the way it is. So let's take a look at Juror Doe's motion or emergency application that was filed today. And you can let me know what you think. Let me just see if I have any questions I can address here before we move on. Any questions regarding the fifth juror? Thank you, Anonymous Canadian Girl, for becoming a member. And Lori Life 360 gifted 5 memberships. Thank you so much for always being so very kind and generous to this channel. Tammy, Truth and Justice. Here we go again, starting Monday. Thanks for the 5, Tammy. And yep, I'll be here with you. BLT, thanks for gifting 5 memberships. You're amazing. Wendy Darling, thank you. Maud Brittany found the pink wave. Okay, thank you, Wendy, for being a member. Sassy Bartender, I've lost complete faith with the feds, the Commonwealth, and Canton. I've never been more disgusted in my life with what's going on. I think a lot of people from the area share your thoughts. Thank you, Sassy Bartender, for the 10 spot. And Wendy Darling, thank you. Peter Pan reference for gifting 5 memberships. You're amazing. Robin became a member. Welcome, Robin. We're happy to have you. Inquiring Mind, do you believe Martin Weinberg will be in the court on Monday? I don't see why not. Let's see. I think he probably will, because we don't know what's going to happen. Remember how, if you were with me I've been covering this case since January. We covered all the pretrial hearings, all the pretrial motions, and during many of those hearings, the judge, flipped the script in the middle of the hearing, called off the hearing, pivoted to a different hearing on a day when that hearing wasn't supposed to happen. So I'm sure that in the interests of who knows what could happen, Martin Weinberg will probably be there on Monday. That would be my guess. Ginny, thanks for becoming a member. Patronus Glow, happy birthday to Tiff Knox. Thanks, Patronus Glow, for being an amazing moderator and for telling Tiff happy birthday. Everyone say happy birthday to Tiff. And also for all of your help and diligence on this channel. Veronica, thanks for becoming a member. And on top, thanks for your super sticker. And here we go into the emergency motion, my friends. Emergency motion of interested non-party juror Doe to extend the order of impoundment of the jury list. Juror Doe, an interested non-party. And that leads to footnote number 1, which just says that juror Doe requests to use a pseudonym for purposes of this motion. Juror Doe, an interested non-party, moves pursuant to Rule 6 and 10 of Trial Court Rule 8, Uniform Rules on Impoundment Procedure, for an indefinite extension of the order of impoundment entered sua sponte by the court, Judge Cannoni, on July 8th of 2024, impounding the list of jurors in this action. Juror Doe was a juror in this action and wishes to maintain their privacy. In support of their motion, Juror Doe submits that the real and present risk of personal harm to the jurors and to the integrity of their service is ongoing. See Order of Impoundment, quoting Commonwealth v. Fujita, 2015 case. Therefore, there continues to be a risk of immediate and irreparable injury should the juror list be made public, and good cause exists for an indefinite extension of the order of impoundment. In further support of their motion, Juror Doe relies on their affidavit and a memorandum of law filed herewith. Also filed herewith are proposed findings in order and an affidavit of service reflecting compliance with Rule 4 of the Uniform Rules of Impoundment. Wherefore, Juror Doe, an interested non-party, respectfully requests that the court grant their motion and enter the following relief. 1. Permit Juror Doe to proceed using a pseudonym for purposes of this motion. 2. Find that good cause exists for an extension of the order of impoundment of the jury list in Commonwealth v. Read, Norfolk Superior Court, docket number. 3. Extend the order of impoundment of the jury list in the Commonwealth v. Read, Norfolk Superior Court, docket number, indefinitely, but no earlier than July 16th of 2025. So they're asking for a 1-year, at least a 1-year extension on the order of impoundment that was due to expire today, and all of the jurors' information would be made public today. Respectfully submitted, Juror Doe, by their attorneys, Andrew Donald, Cavani Jr., Andrew DiCenzo, Christopher Hayes Wojcik, and Mavrikos, and they are a Worcester law firm. I am not familiar with them. If any of you are, you can let me know. Lady in Boston, thanks for the 5, says the Commonwealth framed Sean Ellis. Boston PD officer was unalived. He spent over 2 decades in prison. Everyone should watch Trial 4 on Netflix. Thank you, Lady in Boston. Thanks for the 5. I think you pointed that show out to me before. I haven't had a chance to read it yet. And let's take a look at the affidavit of Juror Doe. Now comes Juror Doe, a pseudonym who on oath deposes and says as follows: I am of legal age and have personal knowledge of the facts set forth herein. I was a member of the jury that was seated in the recently concluded trial in the above captioned case. Up here it says Commonwealth versus Karen Read. I just retained counsel to represent me. I have read the impoundment order entered by Superior Court Associate Justice Beverly Cannoni on July 8th of 2024, which found that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. As I read the court's order, it is scheduled to expire on July 18th unless it is extended by the court. I submit this affidavit in support of my request to extend the impoundment order entered on July 8th. I'm asking that the impoundment order be extended indefinitely because I am in fear for my personal safety and the personal safety of my family if the names of the jury are made public. I have read the impoundment order and noted on the very first page that individuals associated with this case have been charged criminally with intimidation. I am frightened for my personal safety as a result of learning that someone associated with this case has been criminally charged with intimidation. I think that they're referring to Turtle Boy, aka Aiden Carney, but there are so many people who are Karen Read adjacent that are all going out and trying to get restraining orders against each other that it's hard to keep them all straight. So this is a real thing. It's a real thing. If you're out there in the cesspool of Twitter, you know, and I know because you send it to me because I refuse to engage in that nonsense over there. But you know, you've seen it. And imagine this just goes to show you, first of all, what a great job they did picking this jury, because if they were able to find something like 19 people that were able to not know what was going on in the vitriolic social media world about this case and how people were personally attacking each other because of their opinions on this case, they did a great job picking this jury. If they really found, 19 people initially who really didn't know what was happening out there. But there are some people who have lives and who are not out there on social media constantly looking and for all of this vitriolic drama. But the fact that Judge Cannoni mentioned this in her impoundment order, I'm not really sure if that's something that I agree with. I also recall testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in this case. I do not know any of the specifics of any such harassment, but I fear that my family and I will not only be harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. I can think of at least 3 jurors that talked about harassment. And you know that because we went over the motions. We called them motions in lemonade after a while because sometimes we have to inject a little humor into the cases that we cover. Otherwise, we're just going to cry all day and get angry and outraged and throw things at our television. But in one of the motions in lemonade, the defense was trying to keep out any evidence of any of these witnesses like Jen McCabe, Allie McCabe, Colin Albert, Chris Albert, talking about any alleged intimidation or harassment, let's call it harassment, that they had allegedly been subjected to during the pendency of the case before it hit trial. Charges were filed against Aiden Cardi and probably others too. So I don't want to single him out. But he hasn't been convicted of anything. And the judge said during that motion in lemonade, well, I'm not going to allow any direct testimony or any questioning about the harassment of these people. But if it comes up organically from the witnesses, I'm going to let it in. We talked about that at length, and I thought that was a real problem. So what happened during the trial? It's magic. Organically, it came in because organically, Jen McCabe said something like, when she was being questioned about her 227 alleged Google search that her phone allegedly made of Hoslong to die in cold, when she was asked what it was that she typed into her phone, and she said, I don't know, or I don't remember. And Alan Jackson said, what do you mean you don't remember? It's everywhere. And she said, well, yeah, it's everywhere because people were harassing me and it's harassment. And she started to get into it. So it came out. And then it came out again during Allie McCabe's testimony when she was being questioned about her Life 360 data and why she never told anyone about it and why there are these weird screenshots of these text messages between her and Colin Albert. And she said, well, I didn't need them until we started being harassed. And then the same thing happened with Colin Albert when he was on the stand. And Colin Albert said, again, this all happened when my family and I started to be harassed. And you can tell me in the chat if there was anybody else who testified, right, Sharma Lily, exactly, which I don't believe it came up organically, because if you think none of those people were watching YouTube and the coverage of the hearings and the motions, I got a bridge in Brooklyn to sell you. So people knew, perhaps, maybe, my opinion, that when they were testifying, if they brought it up organically, the judge was going to let it in. And I thought that was highly prejudicial because none of that had anything to do with Karen Read, the defendant in the case. It had everything to do with someone else, a third party. Did Brian Jr., did he bring that up to you, Amanda Murray? Little Brian, whose birthday it was, who will never have another happy birthday again because of all this that happened on his birthday. Right? Simply Bell supposedly had opened a door, but that was the pretrial ruling during that motion in Limine, and I knew it was going to be a problem because all they had to do was bring it up organically, and it was coming right in, and it was highly prejudicial, in my opinion, because it had nothing to do with Karen Read. It wasn't Karen Read that was harassing and or allegedly intimidating these witnesses. It was somebody else. So, in my opinion, it shouldn't have been allowed in, but it was. And now this juror Doe, is coming out and saying, I heard that during the trial, and it scared me. He or she says, I do not know any of the specifics of any such harassment, but I fear that my family and I will not only be harassed if the names of the jurors are made public, but our personal safety will be seriously compromised. And you know what, you guys, that's a really big deal. That's really scary. That's really important. And there are people out there who have nothing to do with this case personally, but who have opinions about this case or who speak about this case on things like YouTube, who have also been personally threatened, personally doxxed. Their children have been personally threatened. It's real. And I heard Peter Tragos, the lawyer talking about this earlier today for a bit, and he said it happened to him. Nobody's off limits here. So if you think that a juror would be off limits, I say no way. Because anybody who knows what's going on out there in the land of the crazies knows what's going on out there in the land of the crazies. And it's a real threat. And I think it's horrific. Nobody should be threatened on either side. Thank you, Mama Shea, for the 10. Came in late, so a bit behind, but glad to have your channel. So glad to have you here. Thank you so much. And Robin, thank you for becoming a member. I think you're going to like it here. Lady in Boston, we covered that. Everybody go watch Trial 4 on Netflix. So this is real. This should not be taken lightly. And I don't think, and this is a problem for the jury system too. We saw this in the Maya Kowalski case, for those of you who watched the Maya Kowalski coverage with me. And that was a civil case out of Florida. And after the verdict came in for something like $260 million on behalf of the plaintiff, Maya Kowalski, the defense went to Reddit, like legit went to Reddit, pulled theories off of Reddit about juror number 1 and juror number 1's wife, and how juror number 1's wife was watching YouTubers, LawTubers. I was mentioned in those papers. Recovery Addict was mentioned. And a lot of other creators were mentioned in those papers. That juror number 1's wife was in super chatting people and giving money and talking about what was going on, but she wasn't. And the defense in that case, the hospital, actually asked the judge to give the defense cell phone records of juror number 1 and his wife, saying that they must have discussed the case and that would have been improper. And it was crazy and it was scary. And juror number 1 went to court and he was called in for a hearing and it was public and he was on camera. Yeah, shout out to Recovery Addict, 100%, love that guy. And I said at the time, this is going to put a chill on people who want to serve on juries. They're not going to want to do it. And this is happening in this case now as well. And it's a problem when these people are allowed to run wild out there and start threatening anybody they want behind fake names, fake accounts. And we know who all of these people are. We don't need to name them. But each of them have about 20 sock puppet accounts, and they go out there and they attack anybody because they were trying to shut us up about talking about this case. And that's their method. And since Elon Musk took over that cesspool, it's a lot less regulated. It's like the free for all. It's like a Wild West. So I can see this juror's concerns. These are real concerns, and they should not be tolerated by the court. And I think that there are some charges coming against some of those people that I'm talking about, that perhaps they may want to take a step back and stop doing what they're doing out there because the threat is real for these people. Paragraph 10 goes on to say, during our jury deliberations, we could hear protesters outside screaming and yelling. Well, let's go back. How many days did they deliberate? And who else showed up on those days of deliberation? Because when I went to court, agreed it was not during deliberations, it was during a regular trial day, there was nobody screaming and yelling outside. There were supporters outside the courthouse. They were not screaming and yelling. There was some screaming and yelling that occurred during deliberations when some counter protesters decided to show up. So again, this juror Doe is not picking a side here. They're just saying, we heard protesters outside screaming and yelling. Remember, there was what was it in the end, a 200-foot buffer zone eventually? So these supporters / protesters / people in pink people, as they started calling them on court TV, were at least 200 feet away from the courthouse. Cindy says, this juror is paranoid to the point they imagine things happening to them when they're not. Well, if their name and address and identity is released, do you think this is a fear that is irrational? That this is an irrational fear? When we know for a fact that on the other side of this, people related to, I don't know, one of the troopers involved in this case who may or may not be suspended without pay right now, were calling people's employers who didn't think Karen Read was guilty to try and get them fired from their jobs. So I don't know that this is I don't think this is paranoia. I think this is a reality of what's going on out there. During our jury service, members of the jury would meet at what was supposed to be a secret location to be transported to and from the courthouse by bus. This was something else we were wondering about during the trial, whether or not the jurors were coming in together by bus or if they were showing up and having to walk from their cars or going in a back door, but they were meeting at a secret location and being bussed in. After being discharged from jury service on July 1st, 2024, we were taken by bus back to what was supposed to have been a secret location where we observed what appeared to be members of the media, including photographers. Okay, that's just wrong. That's just whoever was following that jury bus the day that they were discharged should be, I don't know, ticketed. Like, that's just wrong. The jurors did not have to speak out if they didn't want to after this trial was over. They could have if they wanted to, but they were not required to. And I think it's pretty terrible that the bus was followed and that they get off the bus and all of a sudden there's cameras in their faces and microphones. Doesn't say that, but what appeared to be members of the media, including photographers. So now who knows if their pictures were taken. Remember what happened that one day that it wasn't court? They brought a juror in to be questioned into the courtroom, and court TV pool camera guy didn't turn his camera off. But in his defense, he was not told to turn off his camera that a juror was coming in. And then the judge ordered no video for the rest of the morning. And there was this terrible Zoom camera that was pointing upwards in the worst possible angle of Jessica Hyde, who was testifying that day. So the court was real diligent about not trying to get the jurors on camera. And then there's photographers that show up when they get off the bus. I think I'd be afraid too. I don't think that's an irrational fear. Here she says, I was so much in fear on my way home that I pulled over to the side of the road to see if I was being followed. Thankfully, I was not being followed, but that was and remains my mindset. If juror names are made public, we will be constantly threatened and harassed, and there will likely be a physical confrontation at some point. What else did they see if they've been following this case now on social media? Because they were not supposed to look at social media during the trial and during deliberations, but after they were discharged, they could go look at whatever they wanted to look at. What else did they see? Members who were related, people who were related to certain witnesses in the case that were out there on video, literally threatening people. Right? So is that a legitimate fear? I think it is. Here she goes on to say, since being discharged from jury service on July 1, 2024, I've read multiple news articles about the case and the attention that this case has garnered across Massachusetts, New England, and the country. There are clearly people who have very strong opinions about the case and about the jurors who deliberated over many days. I've seen articles, comments to articles, and postings about the verdict saying some very nasty and dangerous things. I've seen them too, so have you. Some individuals have expressed outrage and anger that the jury did not acquit the defendant. Some individuals have expressed outrage and anger that the jury did not find the defendant guilty. Interesting that outrage is the word that they use when we are outraged was part of David Yanetti's spiel. As you know, we have an emoji. Put the we are outraged emoji, members, into the chat. We are outraged. All right, hold on. I got to find. There's a comment that just flew by that I need to address. So just give me a second. As Shay Howard says, if you're scared, get off the jury through some excuse. Not hard. Really? This person is saying they were scared after the case was over. Is that what this person should have done? When they dedicated 10 weeks of their life? They didn't know what was going on the outside. They didn't know because they were instructed every single time they left the room, please don't do any outside research. Please don't go on social media. Please don't. From reading this affidavit, it seems to me this person did not become afraid until they get off the jury bus and they're surrounded by photographers. So I disagree respectfully with your comment because there's so much vitriol on both sides of this case. Just yesterday, I read an article in the Boston Globe with the headline, Karen Read case ended in a mistrial, but the diehards haven't given up. See Exhibit 1. I have that article pulled up. I want to read it with you because for a lot of you, the Boston Globe is behind a paywall. In approximately the 12th paragraph of the article, an administrator of a Karen Read-focused Facebook group was quoted as saying, the people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and it's now at an 11.5. The article characterized this increase as a rising rage. Remember also, there were 6 women on the jury and 6 men in the final jury that deliberated. Later in this July 15th Boston Globe article, another individual interviewed by the reporter stated, people are insane about this case. If they don't agree with you, they'll try to dox you. I understand the term dox to mean that individuals will publicize someone's personal information, including someone's residential address, occupation, business address, etc. Publicizing my personal information in this context exposes me and my family to unwanted and likely surprise encounters with strangers who likely have an axe to grind with any juror. That, my friends, in my opinion, is a problem. I've seen social media posts that were very demeaning of and attacking the integrity of the trial judge. If someone is going to attack a sitting judge, I see no reason why they would not demean and attack verbally and physically a juror who sat on this jury. And I have to agree with that statement as well. And I'm sure that the judge knows what's going on out there with regard to her and her own personal safety. And who knows what kind of crazy emails she's received and what kind of crazy complaints. And by the way, I see somebody out there like calling for people to make complaints and putting the form out there. Do not file a complaint against Judge Cannoni. Don't do it. Just don't, there's no reason for it. You don't have standing to do it, first of all, someone who's not involved in this trial. And why are we going to stoop to that level? What would even the point be? So I'm sure as she's reading this, she's like, yeah, I know personally. I'm sure that all of the lawyers in this case on both sides have received threats and nasty emails and horrible things are said about them out there. And it's not right. It shouldn't happen to anybody. Nobody should be demeaned and attacked verbally and physically. 17. I understand that there are individuals who are upset that an impoundment order was entered and that they are actively seeking the identity of all the jurors. For example, my attorneys have made me aware of a video posted by a blogger/journalist whom I understand to be a person who has been charged with witness intimidation related to this case, speaking about the trial and the jury's inability to reach a unanimous verdict on all counts after trial. In the video, the blogger initially states that he has identified the jury foreperson in the case. Not only does the blogger state that he has identified the jury foreperson, but also where this person lives and what he does for a living. A link to the video can be found here. And then they cite a link to it, to an X post. In this same video, the blogger demands to know the identity of the, quote, expletive, so they don't even write the expletive in there, idiot on this jury, end quote, who did not vote in his preferred manner. Okay, so it's a he, this blogger. And further, that, quote, whoever did that subverted justice, like they helped cover up for a murder. As far as I'm concerned, F them, that's what I think. The blogger states in another video posted to X, quote, who outed the Chesna juror? Remember that? The one woman who hung the Michael Chesna trial in July? And then down below, the footnote is Commonwealth v. Lopez, Norfolk Superior Court, and the docket number, which, by the way, was also in front of Judge Cannoni in the same courthouse. And I understand, I think the jury was hung twice on the Chesna case. Am I right about that? You guys can correct me in the chat. I don't pretend to know everything, but I do know a lot about this case. Not everything about the Chesna case, however. Again, quoting the blogger, the jury lists are public. So I got the jury list and I went down the list and I found the juror who hung the jury and I shamed her as I should because it's shameful, end quote. A link to this post can be found here. And that is an X post as well. 20. I understand that the above mentioned blogger has been accused of harassing witnesses to the case, including by organizing crowds of people to harass them outside their homes. And I'm aware that he has made statements in a blog from 2023 to the effect of, quote, murderers and those who cover for them do not deserve to live a comfortable life, while Karen Read suffers and fights for justice for John O'Keefe. See Exhibit 2. We do not have the exhibits that are attached to this motion. I don't know if anybody has them. If you have the exhibits, you can feel free to email them to me at fanbase@mlittlelaw.com. If, as he has stated, this blogger believes that members of the jury on which I served, quote, helped cover up for a murder, end quote, and he further believes that, quote, those who cover for murderers are legitimate targets of harassment, I fully expect that members of the jury will be subjected to efforts to harass and shame them with a very real probability that some physical confrontation will inevitably occur. And I don't know if this is a man or a woman who's writing this. So I can't opine as to why they keep talking about some physical confrontation occurring. Maybe because they've seen some physical confrontations occurring in videos on that same platform by some other people, like I said, who are related to witnesses in this case. Maybe. Let's check in with you over here. David Reese, thanks for the 5, says Allie McCabe brought it up first. Jen McCabe laid it on thick. Did Allie testify before Jen? I got to go back and look because I don't recall that. But thanks, David, for the 5. Michelle and Pilgrim Shadow and Beck Edwards all became new members. Thank you. Thank you so very much. Welcome. Welcome. Set up like a bowling pin from Truckin', says Pilgrim Shadow. Thanks for the $5 song reference. Another Grateful Dead reference. Thank you so much. Grateful Dead is going to be honored at the Kennedy Center. Did anybody see that? My mom sent me that this morning. I didn't see the actual article, but I think she said she heard it on the news or on the radio or something. Let's Tango. Thanks for the 5. I have a bad feeling that this is a juror who knows the McA's and doesn't want the link to be made. I'm in New York City, and the jury for DJT had no concerns. Well, they didn't file any concerns that we know of. You think that they know the McA's? I don't know. I think we could argue that any juror in this case might not want their name made public, especially now they're asking for a 1-year impoundment, similar to what happened in Johnny Depp and Amber Heard. I think that's reasonable. Thank you. I'm just a girl in the world for your $10 super sticker. Love you, girl. Chelsea D, thanks for the 2. This juror is a male. They slipped up and wrote his. All right, let's see. Did we already pass by that? I don't know. But again, we don't need to dox this juror either or try and figure out who it is. My concerns are not limited to a particular blogger or to a particular side of this case. I'm aware that there are other outspoken bloggers, commentators, and groups of people who wished for a guilty verdict on some or all charges against the defendant. I'm aware that there have been physical confrontations between the 2 sides of supporters. An example of this is from 2 recent postings by an individual who appears to be a reporter from New Bedford. In today's post, she stated that she was in court today defending against a harassment charge against her and her pursuit of a counter-harassment charge. See Exhibit 3. I don't know who that is. Yesterday, this reporter posted about getting protection from another blogger. See Exhibit 4. While I do not know the facts concerning these court appearances, it is very evident that individuals on all sides in this case have acted irrationally and aggressively over the past few years, which has caused multiple court appearances by parties seeking protection of the courts from other individuals. And that's true. Because if you're out there following the adjacent cases or the adjacent side drama of this case, you've seen it too. In light of the mistrial, there is no end in sight to this irrational behavior, which clearly continues today. Jurors will undoubtedly be subjected to harassment and likely physical confrontations if their names are made public. My affidavit and motion should not be interpreted as indicating how I or any other juror voted on this case, or how I or any other juror feel about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberations. It was an honor to serve on the jury. It was also a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer not to have to respond to these inquiries. However, what I fear is not only will I be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on that jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I'm not prepared or equipped to anticipate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family. Signed, this was on the 16th of July. Today's the 18th, so this was signed on Tuesday by Juror Doe and served on all attorneys and the court. By Andrew DiCenzo. Oh, maybe the exhibits are here. Hold on. All right, Exhibit 1. Oh, that's the article. Okay, I'm going to pull it up actually from the Boston Globe. So let's do that first. Exhibit 2. Can cover up Part 76. Chris Albert confronts loser woman in free Karen Read shirt in Waterfall parking lot for taking his picture. So this is from July 17th of 2023. This is the blog by Turtle Boy Aiden Carney. But this is a report of Chris Albert allegedly confronting someone. So people were hypothesizing earlier that they were afraid that Turtle Boy would do something to them, but this is an article that they're article about Chris Albert. And here's another thing too. Why, in God's name, and I don't even want to bring God into this, why, in the name of the traveling Mary, did Adam Lally have to call every single person who was at the waterfall? Have to call every single, child and sibling of everyone who's in the house that night. It was like so unnecessary. He could have saved all of those people for rebuttal. There was no reason to start this whole ridiculous, vitriolic, he ran defense the entire time that he was putting on his case. It was like a defense of all these people instead of even proving how Officer John O'Keefe died. That was the very last day or the very last 2 days of the Commonwealth's case. Something like witness number, 65 and 66. I mean, it was insane what they did. They could have saved those witnesses for rebuttal if and when the defense put up a case that, Colin Albert was there and that Allie McCabe picked him up and that he ran along the road, whatever that may be. Why did they run defense and put all of these people on the stand, including the young niece and nephew of Officer John O'Keefe? For what? So here's the blog that they refer to as Exhibit 2. Just the same blog, yeah. So this is pretty long here. I'm not going to read it. There's language in there that YouTube is not going to like. Exhibit 3 is a post by Jessica Machado. And this is dated July 16th, and that is referred to in this affidavit as well. And this says, this morning, the individual who's accusing me of harassing her at Norfolk Superior Court during the Karen Read trial has had an opportunity to be heard in front of a judge, but chose not to be. Instead, she claimed that she now needs an attorney as I counterfiled against her this morning. When the judge asked if she realized that there was no court order in place and that she would not get one today if she requested a new date, she said she understood and asked for it to be continued. We now have a new date of July 26th. There is no order. And then again, talking about, these alleged people trying to get restraining orders against each other because they have different opinions on this case. And I haven't been following it, so I'm not really sure. But that's Exhibit 3. Exhibit 4 is a post by, I don't know who this is, Meredith O'Neill. Happy Monday. I figured everyone could use a good laugh after this weekend. TBT, or what is that? Throwback Thursday to the dark days before Just Machado show got Grant Smith Ellis banned from court. I didn't take this video, but it went to me. It was went to me. Probably it's supposed to say was sent to me on a Sunday afternoon in May after I'd set up Dr. Triboy's chair. Yeah, there was all this drama that went on after reporters had to wait outside with their chairs for seats in the courtroom because there was only 10 seats available every morning for the media. And so they were out there causing fights and, stealing each other's chairs and throwing them down the stairs and, something like that. I didn't follow that drama too closely either. But again, if people are out there confronting each other physically, do you think that this juror has a right to be concerned? I do. So the judge ruled on this already. I don't know what time this was filed, but let's take a look at her order. Grant was waging the chair wars. That is one of the names that will not be mentioned on this channel. Thank you, Chloe Albert's Revenge. I appreciate your scream name. Thanks for the 5. Bev wanted the harassment testimony in more than anyone. She will now spin this and use it as an excuse to not allow the defense an inquiry. I don't know. I don't know that she can use that for that. Use that for this for that. I don't think she can use this for that because an inquiry could be done in camera, in chambers, without their identities being released. And so maybe, but I don't know that that's excellent reasoning on her part. But then again, if you were with me during all the pretrial motions and the motions in Lemonade, you know how the reasoning goes. Oh, thank you, Kel. Praying for you, Kel. She says, thanks for all your prayers. Thanks for being a member for 9 months and an amazing moderator. And we are praying for you. Thank you, Lisa, for your super sticker. Lisa MM. Chell, okay. Proposed findings in order. Oh, on the second page of the proposed findings in order, it says 5, through his affidavit, Juror Doe has established that publication of the list identifying. Okay, so maybe that's why there was a lot of talk about physical confrontation. Maybe a woman wouldn't be as worried about a physical confrontation as a man would be. I don't know. I'm not going to pull up that proposed findings in order because we have an actual order, so we don't have to read that. But thank you for that. Anybody who has a copy of that, you can take a look and see what Shell CD is talking about. A Sparky says, how do you expect to remain anonymous during a public hearing? Doesn't have to be public. If they question the jury, you mean? Doesn't have to be done in public. It could be done in chambers. There could be a court reporter there, and a record could be made of it. A transcript could be released later. It could be done by something like audio only, and their voices could be distorted. So I think there are definitely ways to protect their identities, and I think that their identities should be protected, quite honestly. I think that they should. Chloe Albert's Revenge, thank you. Their feelings get hurt and they say it's harassment. Are you talking about people on the other side of Turtle Boy's articles? Is that what you're saying? That is the witness intimidation statute in Massachusetts. It's a very strange one. It's the only one, I think, in the country that allows for hurt feelings as grounds for witness intimidation. Let's take a look at the order that the judge issued today. Findings in order on Juror Doe's emergency motion to extend July 8th, 2024 impoundment order. July 8th, 2024 impoundment order. This matter came before the court on the emergency motion of Juror Doe to extend the July 8th, 2024 impoundment order entered by this court. Upon review of the motion and supporting documents, including the affidavit of Juror Doe, the court makes the following findings and order. This case has garnered significant and divisive attention in Massachusetts and across the nation. Actually, it's international. All my international friends, please tell us where you're from in the chat because the world is watching, my friends. The world is watching. Viewers are all over the world. Individuals associated with this case have been charged with intimidation, which charges remain pending. 3, Juror Doe has submitted a detailed affidavit, which I find to be credible. 4, Juror Doe is in reasonable fear for their safety and the safety of their family if the list of jurors is made available to the public. 5, through their affidavit, Juror Doe has established that publication of the list identifying the names of the impaneled jurors will present a real and present risk of personal harm to jurors and the integrity of their service. Through their affidavit, Juror Doe has established that there is a continuing risk of immediate and irreparable injury should the jury list be made available to the public at this time. Through their affidavit, Juror Doe has established good cause to extend the impoundment order dated July 8th of 2024 until and unless otherwise ordered by the court. This order shall not preclude any juror from identifying himself or herself and or from speaking to the public about his or her jury service. Okay, so she's not even putting an end date on it. She's saying, we're going to extend my impoundment order until and if I order it be unimpounded. And that is dated today. Justice Beverly Cannoni of the Superior Court. And I think this may be the first order or decision of this judge's that I actually agree with. What say you? On top, thank you for the super sticker. Chloe Albert's Revenge, thanks for the 5. I was here since Lemonade with you. Her courtroom is Narnia. It is. It's like walking into the Lion, the Witch, and the Wardrobe is like walking into the wardrobe. And you never know where you're going to end up on the other side of it. Scott McGinnis, thanks for coming in, says, but there has been no physical confrontations outside of court or threats of any kind made by the Free Karen Read peeps. This lawyer was talking about the McAlberts assaulting Boy and Grant assaulting Judge Machado. I agree, but do you think, Scott, that their names and identities and addresses should be released to the public? Does anybody disagree with this decision? Do we think this is in the best interests of the people who served on this jury, who gave up 10 weeks of their life to listen to this case, to hear this case? Do we think that it should be their names should be made public right now, today, and identities? I don't disagree. Hello to Arizona. Hello, Michelle Young. Mandolin Wind. But Melanie, wouldn't the judge have granted this without all the histrionics? Well, I think there has to be a good faith basis for it. And I think, the more detail you put in there, the better chance you have of your motion being granted, right? So I don't think that you can just come out and say, okay, I fear for my life without giving examples of why you're in fear for your family and your safety. So I don't think it was overkill. I don't think it was hyperbole. Boston, Mass. 781. If I was a juror, I would not be afraid. I don't know. Some of the jurors said in their affidavits that the defense submitted that they were intimidated by Brian Albert sitting in the courtroom during closings. I don't think that's unreasonable. Dawn, thanks for the 10. Impound the names for decades. Free Karen Read people don't want to know them. We just want the truth of what the verdict was, right? I mean, I don't know. I guess it's transparency, and that's why they release the names of jurors. But I would feel fear for jurors in any case, especially one like this. Right, gorgeous mess. I wouldn't want my info out there either if I was in the jury. I wouldn't either. And at what point are people going to say, listen, I don't want to serve because I saw what happened in the Karen Read case and those people were attacked mercilessly. And I'm not going to serve. And I think everyone should serve. But if this kind of stuff keeps happening to jurors, nobody's going to want to serve. And then who are you left with? You're supposed to be tried by a jury of your peers. Charlotte, thank you for the 3. Lack of respect for juror Doe is a little sad. Yeah, I find this to be a very real, very credible situation. And I don't think that it's out of line. Lorraine, thanks for coming in from Canada. Wait, Exhibit 3 happened today, but the motion was filed on Tuesday. Am I getting this wrong? If filed on Tuesday, how do they know about Machado? I think, hold on. Go back to it. Today's the 18th, right? And some of these exhibits are these tweets were July 15th. I'm still calling them tweets. I don't care. I know they've changed their name. July 15th, July 16th. But that was not filed. Let's see. I think it was filed today. It was filed on the 18th, which is today. And it was ruled on today. It was signed on the 16th. Did we see anything that was after the 16th? I don't think so. I say Twitter too, don't be sorry. I'm not sorry. I'm not sorry. I stole the money. Thank you, Jennifer Machette. Janelle, thanks for being a member for 9 months. The court should never release juror information. Let jurors put themselves out there if they want to. I agree with you, Janelle, but people want transparency. I got to know who everybody is all the time. I don't agree with it. Let's take a look at this article that the Boston Globe posted on the 15th. It was updated on the 15th. And let me know if you didn't know anything about this case and you had just served on this jury and you read this article published in the Boston Globe, would you be potentially intimidated or afraid? Oh, R.I.P. Bob Newhart. Sad. And here's the article. Karen Read's case is over for now, but the diehards haven't given up. Do you recognize anybody in this picture? Jack Carney, it says right, of Canton, with other Karen Read supporters on a sidewalk in Dedham on Sunday. This article is by Beth Teitel, Teitell, updated July 15th. Dedham. The TV cameras have moved on. The man wearing the blonde Judge Beverly Cannoni wig is gone. The street is no longer lined with people bedecked in pink holding Free Karen Read signs. It's a weekday afternoon outside the Norfolk Superior Court, and where Read's supporters once reigned, some with their righteous outrage and their beach chairs, there is instead a farmer's market. A band plays Sonny Rollins. A child climbs into a fire truck, brought just for that reason. A woman carries an armful of sunflowers. But the pastoral scene is deceiving. July 1 end of the trial wasn't the end at all. It was a mistrial, a cliffhanger, an invitation for yet more obsession over a real-life situation that's as sad as it gets, but for many has turned into a binge-worthy true crime drama, and they get to be part of the story. Those in the trial's grip are still out protesting, still fighting on X and Facebook, still buying Read merch. The Jackson Yannetti 2024 baseball caps named for the defense attorneys make a nice keepsake. Indeed, just 6 miles away from the Dedham courthouse where they got so chummy, the old Karen Read was framed gang reconvened last Wednesday. Once strangers, they have become people who hug hello and ask after each other's family members. They have gathered in Canton, protesting in front of the offices of Norfolk District Attorney Michael Morrissey, one of their many nemeses. Here's another photo. It says, the caption is, from left, Jack Carney, Kathy Carney, and Gail White held Carney, not to be confused with Aiden Carney. This is a different spelling, Carney. Held up signs supporting Karen Read outside District Attorney Michael Morrissey's office in Canton. Morrissey, gotta go, reads one sign. Justice is coming, promises another. The weather app shows 88 degrees, but the air is thick and it feels hotter. The group is huddled on a small patch of grass between the road and their enemy's parking lot. Shade is scarce, but the crusaders aren't stopped by humidity. This is a busy week, said Scott McGinnis. Hi, Scott McGinnis. You're quoted in this article. Scott's in the chat. Say hi to Scott, everyone. This is the busy week, said Scott McGinnis, as he describes the demanding schedule of a Read diehard. Today, he's at a protest, and he went to one on Monday, too, in South Boston, outside of the state police barracks. He spent Tuesday night at a meeting of the Canton Select Board. And tomorrow, Thursday, he'd be heading to Dedham to support the blogger known as Turtle Boy in court appearances related to his coverage of the case. McGinnis lives in Shirley, and sometimes the commute to his Read job takes an hour or more if the traffic's bad. But I feel like I'm letting people down if I don't go, he said. It's been 2 weeks since Judge Cannoni's declared a mistrial, leaving unanswered for now, for some, the question of whether Read drunkenly backed her Lexus into her boyfriend and left him for dead in the snow on a lawn in Canton in 2022, as the state alleges, or whether she was framed by the people inside the house, as her attorneys argued. If you indulged in a brief coma on mistrial day, such as the ongoing intensity that you could be forgiven for thinking the trial was still in session, and not just because it's still spinning out actual news, leaks about the jurors' thoughts, the motion by Read's lawyers to dismiss 2 charges, the suspension without pay of Trooper Michael Proctor, lead investigator in the case, the suspension with pay of Canton Police Detective Kevin Albert, whose brother owned the home where John O'Keefe's body was found. An administrator of an enormous Karen Read focused Facebook group says he is spending 3 or 4 hours a day on his responsibilities, approving new posts, writing his own, welcoming new members who are coming in droves as Read's fame continues to grow. The people who are on the fringe of being interested in it are now engulfed, said the administrator, a middle school teacher who asked to be identified by his Facebook name, Do Greg, Dooh. Is that correct? Or is that a typo? I don't really do Facebook. The anger level was at a 9 before, and now it's at an 11.5. A rising rage he attributes to the assertion by Read's lawyers that the jury reportedly unanimously agreed to acquit her on 2 of the 3 counts. I've got a fire lit in me that I didn't know needed to be lit, said Paul Cristoforo. Paul, are you in the chat today? A restaurant owner and one of the informal organizers of the resistance. The resistance. You guys are like the resistance now. It was early in the week, and already plans were being formulated for weekend protests in spots from Auburn to the South Shore, some at rotaries, others on overpasses. I'm just as active as I was during the trial, he said. People's rage takes different forms. At least one Read supporter who's unhappy with the judge's handling of the trial has taken to Facebook to post a link to the Massachusetts Commission on Judicial Conduct so that others can easily file complaints against her. Again, I'm going to break from this to say, please don't do that. Please don't do that. Many Read obsessives spend their time on X reading endless posts that dissect once again and possibly forever what Read did or didn't say and who did or who did not hear her say it, whatever it is. Then there are the trial highlight reels to binge for those who miss the good old days. One, A Goodbye to Our New Friends, is a nostalgia-tinted montage of the now familiar courtroom characters, the court reporter, the clerk, the cult favorite ceiling fan, with Sarah McLachlan's emotional I Will Remember You for a soundtrack. Jay, its creator, asked that his last name not be used because, quote, people are insane about this case. If they don't agree with you, they'll try to dox you, end quote. He's a former insurance adjuster who became so fascinated with true crime that he cashed in his 401k to start a trial-focused YouTube channel. His Read montage was a hit. It got I guess that's 1,700 likes. But even so, he found dealing with both sides of this case so unpleasant, he said, that he vowed not to cover a retrial. Could it be a person with the strength not to tune in for season 2? That's the end of that article. What say you, my friends? What are they hitting on Auntie Deb? I don't think that was Auntie Deb. We love Auntie Deb over here. Auntie Deb came on one day with me while we were waiting for a verdict and entertained us for like a whole afternoon. Thanks, Debbie. Lorraine, we filed this. I mean, we covered that already. And Janelle, we've covered that already. Wendy, darling, so what's Bev going to do about this? Thanks for the 10. Can anyone be charged, held responsible, or protected? What under the law can be done? She, as she likes to say, has the discretion and the right to keep that list impounded. So she can do that. And I think it's the right thing to do for now. I do. I have concerns about the jury's safety too. I had concerns when they weren't sequestered. I thought they should be sequestered. They weren't. I don't know what you mean. Like, who can be charged with what with regard to this? People that have been charged with certain things, restraining orders are flying around. I don't know. But I think the purpose of this motion, this emergency petition by this juror Doe, was to protect their identity for at least the time being, or at least a year. That was the relief that the juror wanted, and the judge granted it. I wonder how many saw what happened to Paul from the Maya jury. That was juror number 1, right? Chloe Albert. That's what I'm talking about. Chloe Albert's revenge. Juror number 1. Sarah and Schwach and Hara give to 10 memberships. Thank you, Sarah, so much. Thank you. That's very generous of you. Justice for all 444. Thanks for the 10. Don't disagree with impounding the jury information, but the defense should have access to the truth, whatever it is. Yes, I agree with you. They should never prevent the administration of justice, no matter the outcome. I agree. And that's why I'm pointing out the case of the trial of Chris McCowan, who is in prison still for the murder of, why does her name keep slipping in my mind? First name's Krista, but Krista Worthington. Krista Worthington back in 2002. There's not that there's no precedent for it. It can happen. And like the judge likes to say, she's got the discretion, right? She always says that. Angel Castillo, thanks for the 5. They're up against a corrupt police department, so I wouldn't want my name out there either. You've seen what they did to one of their own. These are the concerns. It's not just Turtle Boy that they're afraid of. And I don't really think that they are, because that article that was attached was about something that Chris Albert did, right? So I don't know. when I was listening to someone else talk about this earlier, that kind of made it seem like this juror might be afraid of Aiden, but I don't think that that exhibit showed that. So not sure. Casey, thanks for the 5. It's in the public interest to know the names. However, being a juror walking into this den of chaos, I would be overwhelmed and concerned for my safety. It's in the public interest to know the names, but maybe not. Maybe identities should be protected. I mean, in the interest of transparency, look, the lawyers who know who they are because they ran those background checks on every single one of them that the court ordered, those Corey checks before they were able to serve or before they were sworn in. Rachel Doe signed 7/16. Turtle Boy article was from 7/17, Exhibit 3. Okay, so maybe the person signed that on the 16th and they added it in afterwards. I don't know. Maybe because they didn't file it until today, something popped up after, and so they added it in. I don't know. Thanks, Rachel, though, for the 5. Is there anybody out there who thinks that the jurors should be doxxed right now? Classic Clippy, yes, but people are blaming Turtle Boy. Yes, that person did that on the other channel, made it look like Turtle Boy. I don't know. You guys are talking amongst yourselves. You're talking amongst yourselves. Chuck says, disqualify me. Yeah. Risa, why couldn't the juror just ask to remain anonymous because of wanting privacy? Was that ridiculous? Affidavit necessary? It was over the top. I don't think so. I don't think it was over the top. I disagree. I think it was they had to point out reasons and give a reasonable reason. You can't just say, I don't think I want privacy is enough. I think they have to be in reasonable fear of harm. And by pointing out certain examples, I think that they made a very strong case. And they had to go out and hire their own attorney too, which is unfortunate. And we saw that as well. We saw that in the Murdoch case with all that stuff that happened with, the court clerk, Becky Hill. And all of that stuff involving misconduct, and all those jurors had to come back too, and some of them had to hire attorneys. It's crazy. Who's gonna wanna serve on a jury? Hey, Sparky, what's the chances of Juror Doe hiring a lawyer to collect money on her? What do you mean? Collect money on her experience? I don't know what you mean. We don't know if it's a she or he, first of all. And who are they gonna collect money from? I'm not really following. I'm not really sure what you're asking. Like they're gonna sue somebody? I don't see any cause of action there. Susan still wants to see the 2 numbers pulled as alternates and why the other was removed the day of deliberations. We don't know anything about that, and I don't think we will know why that juror was. Estrella says they were not real reasons. You don't think those were real reasons in the affidavit? They had exhibits showing the fear. Would you not, Estrella, would you not be afraid if you were a juror and your name was about to be released, seeing what those people are doing to each other out there? I don't know. I think it's reasonable. That's my opinion. You can come for me in the comments respectfully, but any idea what will happen Monday, says Lee. The juror, the judge, Judge Canoni, could rule on this motion about whether or not they should call the jurors back and ask them questions about whether or not they agreed on 2 of those counts. The judge could rule on that. She could order a hearing. She could say, I'm going to take it under advisement. Let's pick a new date for the trial. May just be a scheduling hearing. I mean, that's what it says, right? I looked it up. It said just like trial assignment part or trial scheduling conference. So it could be something. It could be, all right, let's all pick a date and let's come back then. So we don't know. KPT says, hopefully their attorney's a friend or a family member and they didn't have to pay. Kubi said, no, they didn't have to hire a lawyer. So do you know, Kubi, that they have a friend or family? Who's their lawyer? And Rachel says, this is why I always get out of jury duty. And that's unfortunate because we need good people to serve on juries. And I always encourage anyone who can to serve on a jury. And if you haven't watched Jury Duty on Amazon Prime, go watch that because it's hilarious. It's like a reality show. It's hilarious. Thank you, Justice for All, for the 10. The tenets of our Constitution demand justice be fair and unbiased. Judges are put in place to ensure that. If there are any questions of injustice, then the Constitution demands we determine that. I agree with you. I agree with you. A Sparky, you think the juror wants a book deal? I don't think the juror wants their name out there. I don't think they want a book deal. You know who wants a book deal? You know who got a book deal? You know who self-published a book anyway? Becky Hill, the court clerk after the Murdoch case. Anybody who wanted a book deal, I think, would go out and be talking to everybody. They'd be on Good Morning America. They'd be out there. They would be out there already if that's what they wanted, in my opinion. BLT, Ms. Little, thanks for the 20. Everyone in the chat, please watch Trial 4. Like Karen Read, someone wrongfully accused of Boston PD cop murder, exposing systemic racism and flaws in the justice system. Smart local defense attorneys, too. Just saying. Free Karen Read. Thank you, BLT. Everyone go watch that tonight. Where can we find it? It's not new, right? Isn't it kind of old? Prestige Worldwide, how are you, my friend? It's happy hour in California. That being said, I found that article condescending. Yeah, I think so too. The writer has a fundamental misunderstanding of what Karen Read means. It's far from trivial. Also, the nostalgia video with the only fan was very funny. Yeah, I wasn't a fan of that article. Speaking of fans, I wasn't a fan of that article either. I don't think it really accurately represents what's going on with the supporters of Karen Read who happen to wear pink. But people are outraged in Massachusetts. People are fed up. You've seen what's been going on in your local government and your local police departments for decades. And you're mad as hell and you're not going to take it anymore. And I hear you because I know you write to me and you're afraid of being identified too. So many people are afraid, not just this juror. But I'll tell you what, if I was this juror, I'd be afraid too. And I don't think it's unreasonable. BL says, I wonder if the state victim advocate will pay attorney's fees. I don't know. I don't know. I don't know. Nellie says, whoever put this affidavit together had an agenda to garner attention to certain people. For Boy and Jess Machado, they're anti-Karen. Clearly, I don't know. I didn't read it that way. Especially since they were pointing out both sides, especially since that article was about Chris Albert doing something to somebody. That was the exhibit. I don't know, Nellie. I just don't know. And I don't know if this is one of the 5 jurors who's already come out or was, talked about by an intermediary. We don't know. Or if it's a 6th juror, if this is somebody completely different. We don't know any of that stuff. And I don't know if we're going to find out. Marcello, thank you so much for coming in. Argentina? Nice to see you, Melanie. Bev is going to Bev. If you have to go right, Bev will go left. And it's unfortunate we have to expect the worst from a judge, except for I do agree with her decision that's the first decision that I've really been in agreement with, I have to say. Hi, Cubert. How are you, Cubert? It was so nice to meet you outside the courthouse that day. In fact, way more fear of Alberts and law enforcement here than Aiden. Sad. And I think that one of the other jurors said that. They felt intimidated by the presence of Brian Albert during closing arguments. Karen says, the question is, who would you be afraid of? I think it's the MPD CPT et al. If your name's out there publicly, right, as a juror and you live in Norfolk County, because they all live in Norfolk County, remember, and they get pulled over for, an alleged traffic violation and everyone knows their name and it's public. I mean, I would be afraid. Weird Ryan says, Bettero thinks there is an agenda. An agenda by who? I don't know. I didn't talk to Mark today. I was in the car for 7 hours. I was on a 7-hour road trip today, and I'm here for you guys. I'm here. Bettero said those links from the lawyer were anti-Karen sites. I didn't find the exhibits to be, though. I didn't click the links. Those links were to tweets, right? Heavy metal rehab. They didn't care about any other part of the trial, but show up for closing arguments. They were invited by Paul O'Keefe. He said that in one of his 2 or 3 interviews that he gave, that he invited them because he wanted the jury to know that his family did not think that they did anything wrong. So that's an agenda, in my opinion, as well. Somebody said maybe just move away. Okay, maybe just move away. A lot of people don't have the ability to move and just pick up and don't have the financial ability to do that. Procedural Wise says exactly that's what the movement's about, corruption and bullying. Yeah, and it's going to continue. Bev is back for Monday. She's back on for Monday. Yep, we looked it up, Bridget. Thank you. Thank you so very much. Little Boston says it's a sixth juror and it's all part of the plan. She's just as corrupt as the rest of them, and she used Aiden as a scapegoat. Who are we talking about? She who? Todd says, I think the same person who wrote the notes did this. It is written to leave questions as to who, and they're leaning as a juror. And right, Mandolin Win, thank you. Look at us, she says, or he says. Most of us aren't using our names here. That's right. That's right. And all of those sock puppet accounts on Twitter don't use their real names either. So think about that. Why did they get to be anonymous? And people like the jury, who people are clearly going to be against. At least 50% of the people out there on one side are going to be against them. And you're exactly right. Thank you, Kathy, for thanking me. I appreciate you. Justice for all. Thank you so much. I am a Ran with my MSN. I've always decided to go back to school and get my PhD. Based on the Cameron case, I've decided to go to school and get my PhD in social justice starting September 1st. Congratulations. Thank you. Thank you for your super chat and congratulations to you. And it's never too late. It is never too late to dream a new dream. It's never too late to go to law school. It's never too late to get your PhD. It's never too late to, have kids. Go out there and do all the things you always wanted to do because you can do it. It's never too late. And that, my friends, is pretty much all we have for tonight. Here's the thing. This Ashley Benefield case, anybody following this? We're going to follow it. She has supporters outside the courthouse, very similar to the Karen Read supporters, except they're wearing lavender. They're wearing lavender, and they are supporting her defense in the case of killing her estranged husband is battered spouse syndrome and the stand my ground law in Florida. And it's a real interesting case. And she's got supporters outside the courthouse in Florida, and they're growing. Ashley Benefield. She's a ballerina who shot her estranged husband in the middle of a custody dispute. And what's so interesting about this is she's never given a statement. She's never given a statement. She's never done any media tours. She didn't even call 911. Nobody's ever heard from her. She's going to have to testify, I think, in this case to prove her self-defense claim or her stand my ground claim or her battered spouse claim. But it's really interesting. And I hear some people talking about it like, on the regular Law and Crime and Court TV. And I'm like, kind of disagreeing with what they're saying. She must be guilty because she didn't call 911. Oh, okay. Maybe he was shot in the back and therefore there's no way she could have been a battered spouse. Okay. How about we wait and hear all the evidence? David uses his real name. Anybody who wants to go find David Reese? Thanks, David. So I think I'll do a primer on Ashley Benefield this weekend, and the trial starts, jury selection starts on Monday. But we're going to be here Monday for Karen Read at 2 p.m. So I think we'll start covering Ashley Benefield's case with opening statements, and we'll go from there. Buzzing for truth, Melanie, links are Julie Carpenter anti-Read. Right, but I don't know what it was pointing to. I didn't cut and paste some buzzing for truth. I mean, I'll take your word for it. I'll believe you if you guys clicked on them or cut and pasted them. Shell CD. The little I know of the Benefield case has me side-eyeing her hard. I don't know if I buy the battered spouse defense. I guess that's why we gotta find out what the evidence shows. I'm a little cupcake. Hi, little cupcake. Hi, Nixie. What'd you get? You got Steelies? All right. All right, my friends. Thank you, moderators, for keeping the chat classy. This is a short one tonight, but I wanted to come on and review this with you because I knew you probably had questions. If there are no more questions, we will move on. Keep on keeping on, my friends. Thanks to my moderators for keeping the chat classy. As always, let me just see if there's any more questions here in one other place. For everyone, just please hit the like button down below. It really helps the algorithm and it helps this stream get out there, and it helps to do all of the YouTube-ish type things that YouTube enjoys you to do, like subscribe, it's free, hit the bell so you know when I go live, and all such things as that. I see nothing else here, so we're gonna wrap for tonight. Thank you to my moderators, as always, to my what, did I get your super chat? Who? Michelle? I don't see anything here. Did I miss it? Everything that was here went into StreamYard screwing up again. Yes, Amy, I did it first. Michelle, put your question in here. I'm sorry. StreamYard's really not playing nicely. I was watching Emily Baker the other day and she was freaking out. She said StreamYard was sold to another company and she was having major technical issues. Thanks, Amy. Did you talk about Juror 5? I was late. Yes, we did. That was the first thing that we did today. Done and done. Thank you, Scott Belton. Come dance with me in Mansfield. What's happening in Mansfield? Come to Vegas. Michelle, I was asking the mods. Wait, Michelle, hang on. I'll get to you. I got invoice, but didn't see it pop up. They don't see it on the back end either. You want to just drop the question in here and I'll answer it? The mods, I don't know if the mods will see it. I see Sarah and Shock and Horror gifted 10 memberships, but I think that was from earlier today. Michelle, if you drop the question in here, I'll answer it for you. I'll wait for you because I'm good like that. Oh, thank you. Thank you, Warrior Biatch. I love you, Melanie. Thank you. Smiley Mama's making cookies. Nixie's going to fish. You know, Nicole, I never got into fish. I just was on the bubble. I was like deadhead and I just never transitioned over to fish. Not that there's anything wrong with that. I just like I just never did for some reason. I don't know why. Fish is happening. All right, guys, go to fish. Enjoy it. Have the best time ever. Proctor did not try to get people fired from their jobs, but maybe somebody did that's related to him. It's the StreamYard conspiracy. Kimberly, I was driving when I was listening to Emily, so I could not participate in the chat. She's got like 20,000 people in there. I don't even know that it would even she would even see it. But I would. We both love Dave Matthews, so that would be something cool that we could do together. You know, talk about on a stream. What time for Bev on Monday? 2 p.m. I'll probably go on at 1:30. I'll set it up for you. So sweet, Melanie, giving Michelle this extra attention, making sure her super chat is responded to. I know. I try and see them all. I try and address everyone and thank everybody. People get mad. They're like, "You are." I don't know, Michelle. If any of the mods see it, you could text it to me. Do 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 do. Get some rest, everyone. What's today? It's only Thursday, Cubert. I'll be seeing you before then. Who knows what's going to drop tomorrow, right? Boston 21 has some tidbit of information for you. Okay. All right, Michelle, thank you. It's a good ruling as long as it doesn't interfere with the defense getting the truth about the verdict. Yes. And it doesn't stop jurors who want to speak publicly. Yes, I agree. So I do not think I think that we can separate the two. I think that we can say, on the one hand, yes, we're not going to release the jurors' identities right now out of fear for their safety or concern for their safety. But if any of the jurors want to speak to the media or tell people who they are, they're free to do that, which is what the order says. And on the other hand, there is a way for us to inquire of the jurors and talk to the jurors and ask them if they did acquit on 2 of the charges or 2 of the counts without revealing their identities, because I didn't think that they should reveal their identities if they were going to do that hearing either. So I do think that both things can coexist, Michelle. So thank you for that. And I think that both things can coexist. That is my opinion. And I'm sticking to it. Thank you, Jennifer Matchett, for your $10 super sticker. That is so sweet. And for Sweet for becoming a YouTube member all the way from Sweden. Thank you. We are international here. We are. Oh, thank you, Scott. Hold on. I just want to make sure. that Michelle, that it was your question. Yes, it was. Thank you so very much. All right, everyone. Thank you. And as I always say to end every stream, remember, be cool, be kind, be classy. It's not hard, really. It is so not hard. And listen, the peace sign, I guess, is only allowed to be this way. Somebody told me, because sometimes I flip my peace sign around the other way, that if you do the peace sign the other way, that it means like something bad in maybe the UK or somewhere else. So I guess I can only do my peace sign this way. So peace out, everyone. I apologize if I offended anybody by flipping my peace sign around. I really had no idea. Hit the like button on your way out. I'm going to see you guys real soon. Have a great night.